Appeals from the Magistrate Court. There are three ways of appealing a conviction in the Magistrate Court. The most common route is the Crown Court. Where there is a route chosen, the appeal is heard by the judge in the Crown Court sitting with two magistrates. It takes the form of retrial with the evidence called upon by the both sides in the usual way. So if a case has been appealed against the decision of the magistrate court to the crown court, then the retrial shall happen, and evidence shall be read and studied in the same manner as it was done during the first trial. But this only happens against the decision of the defense. So only defense has the right to appeal in this manner, and prosecution does not have this right, and prosecution cannot appeal an acquittal in this manner. Otherwise, someone convicted in the magistrate court may be able to appeal to an administrative court, either by way of case stated or by judicial review. The case stated are those cases in which magistrates have gone wrong in the law, where there is question of law, and judicial review relates to the breach of natural justice. In those scenarios, decision of the magistrate court could also be appealed in the administrative court. An example of an appeal by way of case stated might be where there is a dispute about the meaning of statute, and the case and the magistrate have sided with the prosecution. So where there is a dispute about the meaning of the statute, this will relate to the case stated, and usually magistrates have sided with the prosecution, and in this manner it could be appealed in the administrative court. An example of an application of judicial review might be where there is one magistrate who was reading a magazine while defendant was given his evidence. So when magistrate was not paying attention, that is a breach of natural justice, because he has the duty to look upon all the scenarios in the best possible manner. So judicial review shall happen in the administrative court against the decision of the magistrate court in this manner. Appeal from the administrative court lie in the Supreme Court on the application of the defense or the prosecution, provided that matter of law of public importance is involved. So if one has to appeal against the decision of administrative court in the Supreme Court, then it should relate to the matter of law which deals with the public importance. But the exception to it is that Supreme Court's appeal are usually not given, and leave to appeal to the Supreme Court is rare, very, 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 very rare. If a defendant considers a sentence passed by the magistrate to be too harsh, he can appeal to the Crown Court, but he must be sure of his ground. If the Crown Court takes that view, far from being too harsh, it was too lenient, it can increase the sentence. So if a defendant goes against the decision of the magistrate court which has been given against him, he might be thinking that he will get a relief from the Crown Court, but the point is that he might get far harsh kind of a decision against him in the Crown Court. So he should be vigilant while appealing.